truth my flame. For the people I fight, rewriting the game. From the streets to the judge, I defend the free. Breaking chains of power, setting liberty. No barrier too high, no law too tight. I'm the spark of hope burning through the night. Fight for the right, let the truth take flight. Echoes of freedom from morning to night. Stand for the soul, turn the wrong to right. Civil rights attorney, I'm your guiding light. Rights in motion. Justice devotion. Facing badges and gavels, I hold my ground. Unlawful shadows fade when I'm around. With every case I pave the way ahead. For equality's rise where justice is bred. From the first to the fifth, I know the fight. Turning darkness to dawn, bringing truth to light. A guardian of law with a heart so true. For every voice out there, see it through. Fight for the right, let the truth take flight. Echoes of freedom from morning to night. Stand for the soul, turn the wrong to right. Civil rights attorney, I'm your guiding light. Rights in motion. Justice devotion. Tune in, stand tall. This is our fight. Together, we ride for justice's light. Subscribe, join in the future so bright. Civil rights live.
Hi, chat. What's going on? It's Brandon Grable, clearly established. And for this weekend's live, I have with me Texas Attorney, retired First Sergeant CJ Grisham, who is not only an advocate, but he is a fighter for rights. And for those of you who don't know, he recently just got done with a trial where he was fighting charges for disrupting a public hearing. Basically, he went to a city council meeting and took advantage of the public speaking moments, where basically you get 3 minutes to talk about whatever you want. When they didn't like the content of his message, they decided to have him criminally prosecuted. And so we are here today to talk about it. All right. And so with that, I'm going to invite CJ on. Let me obviously I'm still getting new at this, so bear with me. CJ,
Hey,
can you
hey.
hear me okay?
I can hear you great. Can you hear me?
Great, I can hear you. Let me go over to the chat. Eventually I'm gonna get the chat up on the screen. That way it's kind of easier for me. But So, welcome. So what I'm going to do is, to the extent there's any questions, we'll kind of go through and we'll look. But before we get started, I'm sure everyone here already knows of you. If they don't, tell them where they can find you on socials.
You can find me Texas 2A Attorney on YouTube, Texas 2A Attorney on X, CJ Grisham on Facebook. I do have an Instagram. I rarely use it. I've got so much I don't. And then I think I'm Texas 2A Attorney on TikTok as well. You can either just type in CJ Grisham or that crazy guy from Temple.
There you go. And I'll be sure to add that if it's already not in the description as well. So what I'm going to do is I'm going to give people some context before we get into your situation where you just had trial, okay?
Sure.
All right, so before I get started, this is actually from your Facebook page, CJ Grisham. Who's this individual we're seeing here on the screen?
So his name is Jason Followell. He initially hired me back in 2022 when the city of Aransas Pass issued him an unconstitutional trespass from all public property because he was upset about his business being raided. And that's kind of how we got to know each other. And he became my client. So that's Jason Followell, and this video was January 16th of last year, so 2024.
Okay, and they're still actually, you were both actually arrested and charged, right? So they're still going after him, if I understand.
We weren't arrested, we were charged, and I'll kind of get into how all that went around as we go through. But no one was arrested, we were just charged.
Okay, we're getting some comments about echo. Is there still an echo?
Hang on, let me see if it might be my. Let's see if that. Whoops. Let's see if that works. Is that a little bit better, guys? Make sure that's a little bit better. Say something to make sure I don't have an echo, because it might be my speaker going to my mic.
Yeah, you might have to. You got any headphones or anything?
Okay, there we go. I think we're better. Hopefully.
Okay. All right. So I'm going to go ahead and play the video if you all have any. Okay. We're getting comments that's better. So I'm going to go ahead and get going on this, okay?
All right.
The city council, and they tried to arrest him just for telling the truth. But wait, what happens next?
Chief Blanchard, you piece of shit.
I'm not going to put on any defamation of character.
That's not defamation, that's a fact.
I don't care. You're either going to respect this place or you're going to be asked to walk out.
I'm going to be arrested. Fine.
Surprisingly, his lawyer was at the meeting and immediately took action. Little did the council know they were in big trouble.
I'm a civil rights attorney, and what I just witnessed was a violation of rights. Let me read something to you. Swear words do not provide probable cause for an arrest because the words, as a matter of law, are not fighting words. We are allowed to talk about what we think about you. If I think the city manager's a piece of shit, I can say that.
You're going to be escorted?
You escort me out, I'll sue you as well, Mr. Mayor.
Do whatever you want.
Oh, you're going to arrest me? Okay, so under the threat of arrest, you just filed.
The police chief disrespectfully told him to come back with a lawsuit. And a couple of weeks later, he surprised them with this.
Last time I was here, Chief Blanchard gave me some advice, and I'm finally going to obey. He said, stop talking and just sue me. Okay, Chief, here we go. These are your lawsuits.
This man exposed the city council, and
So that was
Sorry, I have a train going by. I was trying to mute my mic.
Oh yeah, no worries. So you so that was the incident that caused you to be charged. What exactly were you charged with?
So let me really quick, let me give you a little bit of backstory about why I was even there. So the previous month at the December city council meeting, Mr. Followell had pretty much done the same thing. He had called the city manager a POS, and the police chief as well. He was talking about this $1,200 suit that he grifted from the taxpayers. And so he called me because he's like, hey, what are my left and right limits here? Because they threatened to arrest me. And so I explained to him what the law was, what he could and couldn't say. And he's like, well, what do I do if they threatened to arrest me? And I told him, and by the way, I already asked for permission to talk about our conversations. So what I'm telling you that is normally attorney-client privilege protected, he's given me permission to talk about. So he's like, well, what do I do if they threaten to arrest me? I said, well, if they threaten to arrest you, you shut up and you leave. If they tell you to, if they threaten to arrest you if you don't leave, you leave. And then he says, well, hey, can you come down here and tell them what the law is and explain to them what they're doing is unlawful? And I says, yeah, I can do that. And so I prepared this document that you see that I'm reading. And so I came down there with the intent to explain to them what their left and right limits were on speech, what they could do as a city council, what they could not do, what speech they could squash and what speech they couldn't. And really, I was just reading from what I did was I went and I found all the case law I could find on profanity. And I created this document, and I even handed that document over to members of the city council, actually to the city manager, to hand out to everybody so that they had a copy of it as well. And so that's what I did there. It's a little weird in Aransas Pass because they don't have a sign-up sheet. They say, all right, we're going to move on to citizen comments. And then literally, I guess the first person to stands up and goes to talk. And at that point is when Jason got up immediately and started speaking. So I didn't have a chance to go up there. Of course, what happened to him, you saw at least a clip of that on there. And then I went up and started reading them the case. And of course, explained to them, what I just saw was a violation of my client's rights. And explained I was going to send them a demand letter for violating his rights. And then I went into reading the case law on profanity and what they can and can't do and all the different types of cases and different scenarios in which profanity is protected. So that happened. We got kicked out. I wasn't initially charged with anything. That's January 16th. In March, because I sent them a demand letter, they ignored it. They didn't bother to do anything with the demand letter. So we filed a lawsuit in March. I went back in March, and that's when I had them officially served during their meeting. And then 10 days after I served them the lawsuit, they charged me and Jason to charge Jason with, actually they charged us both with hindering a government proceeding by disorderly conduct. It's a Class A misdemeanor, $4,000 fine, up to a year in jail. I filed my motions to quash because, and it was 3815 is what we were originally charged with. And the charges were both dismissed because they realized they wrote it wrong. So they refiled them again. But when they refiled them, they refiled Jason's charge with different language so that they couldn't overcome a motion to quash. And then they refiled mine as what you just put up a little while ago as the 4205 disruption. And again, I filed the same motions, but because essentially the complaints followed the elements of the offense, it didn't say exactly what it was we were being charged with, just that we were being charged with these things. We were unable to get a motion to quash, and so now we're facing charges. And in Jason's case, I argued all the pre-trials, but then at the last minute, like just a couple weeks ago, at the last minute, the prosecutor told the judge before I could even argue my motions that we've got a motion to have him disqualified because we're going to call him as a witness. And I'm like, there's no way the state's going to call me as a witness against Jason Followell or for any reason, because I'm going to destroy their entire case. But they did succeed in having me disqualified as his attorney. He did have to hire another attorney for his case. And his trial, which was supposed to be the week before mine, was reset so he could find another attorney. And then my trial happened this week.
So that just happened last week. So I want to get through this just to give people some context, right? So you were, just to be clear, your comments were, you said there was no sign-up sheet, but this was during the public meeting portion of the city council. So what were the rules at the time? How long could you talk? Were you within that time frame? Kind of give context there.
Right. So they have what are called rules of decorum, and we're starting to see these all over the place. They've really popped up and really been enforced over the last couple of years. And these are all being pushed down by the Texas Municipal League. But the rules of decorum stated that they're not going to tolerate any, and it's 3 minutes, by the way. You get 3 minutes to speak on any topic you want. The Aransas Pass City Council does not limit comments to the statutory agenda items. Like it's the Texas Open Meetings Act specifically requires municipalities and other government entities to allow comments on at least agenda items. And so, but there are some cities that just allow broad citizen comments. And that's what Aransas Pass was like. And the limit was 3 minutes. You can talk about whatever you want, but it also said you can't use profanity. You can't engage in any personal affronts. And then it did list some constitutionally sound restrictions, such as, you know, threats, defamation. I mean, it's not constitutionally protected, but it's not illegal. And I think it was threats of violence and stuff like that. So really my argument was about profanity, and it was about the whole personal affronts thing. Those are the two unconstitutional areas.
So the element so really there's just one element here, right? That you commit an offense if with intent you prevent or disrupt a lawful meeting, right? Or interfere with the meeting, right? But it sounds like the portion that you were speaking at, it was they weren't doing anything, right? They weren't taking any action or anything because it was it was actually your time to speak.
Right, and they're not even allowed statutorily. They couldn't take any action because it was citizen comments and it was off agenda what I was talking about. And what's interesting is, even though 42, you look at that statute and it says with intent to prevent. Well, the Fifth Circuit has said when it involves speech that there must be a specific intent to prevent that meeting. The speech that you're engaged in, not only do you have to intend to engage in that speech, but that as you engage in that speech, you intend to prevent or disrupt the meeting. The meeting wasn't prevented. It wasn't disrupted. When I was done, I stayed within my 3 minutes. The timer never went off. And then when I was done, I left. And I specifically, you can even tell my intent, because when they're trying to tell me to leave, I specifically asked them, is my 3 minutes up? But the case law has actually made that word. They kind of did a little bit of legislating from the bench. The Fifth Circuit did, because it says when it comes to speech, it must be specific intent, which is actually a much higher level of intent.
Yeah, and so what I'm going to do now is just to give people context who aren't familiar here in Texas or with Texas law about open comments. If you go to the Texas Government Code, Chapter 551, which governs the Open Meetings Act, specifically 007 for public testimony, what's important here is when you go to Section E, it says a governmental body may not prohibit public criticism of the governmental body, including criticism of any act, omission, policy, procedure, program, or service. So do you see that? So these decorum laws, it sounds like, may need to be challenged, right? If you're saying that, you would know better than I, because I've seen your videos, you go to these things all the time. It sounds like to me there needs to be some kind of maybe deck action or facial challenge to these, quote, decorum policies, to the extent it's a violation of not only the Open Meetings Act, but also potentially the First Amendment.
Right. And what's interesting is they brought up at my trial, when the mayor was on the stand, they brought up this 007E and had him read it, where it says public criticism of a government body. And then literally the state says, it doesn't say in there that you can't prohibit, or that you can't prohibit criticism of the mayor. It says the government body. So he can't talk about you, right, Mr. Mayor? He can't talk about the city council. He can only criticize the governmental body. I'm like, oh, I completely attack that line of argument, because it says any criticism of any act. The government body rarely acts. If I want to go after a council member because that act was that he or she voted for or against something individually or even collectively, this idea that the government body, I have to criticize them as a whole and I can't individually criticize. was just such a bogus argument on its face that they tried to make, saying that my speech wasn't protected. And I got when I did my recross on the mayor, I said, wait, Mr. Mayor, are you telling this jury right now that a person has no right to criticize you as a mayor during city council? And he even said, no, they can do that. So it like the state was trying to resurrect him, but he was so stupid he screwed up his own resurrection.
Yeah, that's insane. So let me and for clarity, so your trial took place last week. How many days was it? How many jurors were sitting? And just briefly describe, was this something that required a unanimous jury?
Yeah, so any criminal cases require unanimous jury one way or the other. Otherwise, you get what's called a hung jury. There were for misdemeanors, it's 6 jurors and usually 1 alternate. For felonies, it's 12 and 1 alternate. And sometimes they might have more than 1 alternate. It just depends on how big the case is. If there's a potential for like a jury busting or whatever, they might have more than 1 alternate. But usually in a misdemeanor case, so we had 6 jurors and 1 alternate. The end result was 5-1 in favor of not guilty. And the 1 holdout juror, so thankfully the jury allowed us to talk to them, because otherwise we wouldn't have known if it was 5-1 for guilty, not guilty. Was it 4-2? Was it 3-3? We wouldn't have known that. And so we went back there and it was 5-1, and they said it was 5-1 in favor of not guilty. And the prosecutor was very surprised by that. And then we talked to the juror that was the holdout, and she herself admitted that her reasoning for not budging on guilty is, well, I just feel like, you went there to cause problems. She went outside the bounds of the jury charge. It doesn't matter what she feels. And if she feels that way, but the evidence shows otherwise, that's called reasonable doubt. And when there's reasonable doubt, you have to acquit. And so I do believe if they retry this, I might bring up and file a motion for juror misconduct, because the prosecutor was there when he heard what she said and what her reasoning was for finding me guilty and not going along with the other 5. So he knows very well that should have been a 6-0 verdict if she had followed the law like she was required to. But I could tell you during that whole trial, I even told my paralegal, I said, yeah, I know we've got a problem. I know 4 of them are on our side just based on, how they paid attention and the voir dire and kind of how they reacted to each of the witnesses. And I said, there's 1 that's definitely not on our side that we have to work on. And there's 1 I just wasn't quite sure of. I couldn't really pinpoint one of the jurors. And sure enough, that 1 that I was worried about was the 1 holdout.
Yep. Nope. Fair enough. So, let me just check real quick. I'm getting some comments that there's some volume disparities, so I just want to make sure that you're good. I'm just a little low. So is this better? Let me get from the chat box if this sounds better.
And I can turn mine down a little bit if I need to. I don't know if that made it any different.
No, we should. What I can do too is I think I can change different things, maybe something like that there. But I'm not hearing anything further. I can always speak louder as well. Okay, so all right, so let's move on. So you had 1 juror that basically prevented you from getting the not guilty on this. So as a result, you're at risk of potentially being retried on this.
I'm at risk, but I made some objections because really the jury was given the case, and with less than 3 hours. So they're given the case probably around 2:00 or 2:30, something like that, in the afternoon on Tuesday. The case was basically a 2.5-day case, but by the end of the second day, we had given them by about 2:30 in the afternoon. We handed over the case. We had done closing arguments. And then at about 4:45, they came back and said that they're hung. We kind of debated that a little bit. and they had asked a few questions in that 2 hours. But by 4:45, they said that they were a hung jury. And so he was like, well, what do you guys want to do? And I'm like, I want them to keep deliberating. And we give them an Allen charge. And so we agreed to give them an Allen charge, but the judge released them for the day. And we gave them the Allen charge in the morning. So really, they only conferred for about 2.5 hours, a little bit around there somewhere, before they figured out that they were hung. So the next morning we came in at 9 o'clock. The judge did the Allen charge. And for those of you who don't know what an Allen charge is, when you've got a hung jury, it's just the judge saying, hey guys, look, I understand that you can't agree on this, but understand if you don't come to an agreement, we're going to have to impanel another jury. It's going to cost the taxpayers more money to retry this case potentially. And they're going to hear the exact same evidence that you just heard. So try to come to some agreement, but don't violate your conscience. That's what an Allen charge is. Like, try to figure out if you can come to an agreement, but don't violate your conscience in going one way or the other. So we gave them that Allen charge right at 9 o'clock. By, I would say, probably 10 o'clock. Maybe it was 9:30 that we gave it to them. And probably by 10 or 10:15, they came back and said they're still hung, and the judge declared a mistrial. So what I did was I actually filed an objection, made sure that my objection was on the record, because I just don't think that less than 4 hours of deliberation is, I shouldn't have to be subjected to 2 trials when we didn't force them to try and duke it out, as a jury, and convince each other or talk to each other about the evidence, review the law, review the jury charge, and figure out how to either convict me or acquit me. And that's what I wanted. And so now if they do recharge the case and try to charge me again, I can file a habeas corpus on that for double jeopardy, because I think the case was prematurely ended with a hung jury. I don't think we gave them enough time to deliberate.
Well, and I assume a lot of people might be asking, what's kind of in the back of my mind as well is, we see the law, right? We looked at the elements. So first and foremost, the Open Meetings Act for Texas says the city can't prohibit you from criticizing them. And then all you were doing was reading from case law that had profanity. And then you were also speaking during the public comment period. So it was your time. And so we see the penal code where it says it's you have to disrupt a proceeding. But how do you disrupt a proceeding if it's your own time? So why is it that you think the case was able to even get as far as it did?
So this is my opinion. The chief of police, who is about as corrupt as they come, the chief of police had his feelings hurt. The mayor had his feelings hurt. The city manager had his feelings hurt. I had beat them in court numerous times as they went after Jason Followell. I forced them to have to rescind their cease and desist letter to keep him from talking about the fact that one of the city council members apparently had forged a will for her late husband. And then there was the mayor allegedly dealing drugs from his business or something like that. So I got these cease and desist letters dropped where they were telling him, essentially threatening him with litigation if he continued to talk about these things. I got that removed. I got the trespass removed where he couldn't even go to vote or anything because of he wasn't allowed to be anywhere on public property, anywhere within the city. And then after he beat the city on his, I think it was like, I don't remember how many it was, like 9 or 18 code violations from the unlawful search that they did on his gym. The city appealed it to the county in a trial de novo because they wanted it on the record, and I beat them there. And so I think the only reason they went after me personally is because I'm the only guy that's standing between them and their tyrannical behavior. If they can take care of the one attorney that was willing to take this case and fight back, because no other attorneys, he couldn't find an attorney until he found me. And so they think if they can shut me down, by the way, that same police chief filed a bar complaint against me, trying to get me disbarred for the same speech. And that failed. And that's why they filed these charges, because I'm the guy, I'm that thorn in the lion's paw right now. And
is he still the police chief?
He's not, well, he is, but up in Sinton now, which is where the seat of the county is. And the county attorney, the elected county attorney, Tamara Cochran, is good friends with the chief and his wife. And I got that put on the record as well. He had to admit that they were friends as well. So that's what this is about. This is about a corrupt county attorney, and yes, I'll say it's corrupt, trying to protect her friend, the chief, and his wife from being embarrassed and trying to go after me. So,
well, there is good news from this, though, right? Because of what you did in bringing awareness to this, I'm sure it played some part in it. But the current city council today is not the same city council that was there during your first, when you went there and did all of this, right?
Yeah, well, they've got a whole new, not only a whole new city council, but all the staff. They went through 3 different city attorneys because the city attorneys kept quitting because they didn't want to deal with all of the city's nonsense and unlawful and unconstitutional behavior. So they've got not only a new city council, a new mayor, they've got a new police chief, they've got a new city manager, they've got a new city secretary, as a matter of fact, they swore in a new city secretary when I was there on Monday. And then they've got a new city attorney, and the new city council actually drafted up a what do they call it? Not a memorandum, a resolution. They drafted up a resolution that they would have the city attorney go to the county attorney and essentially say, we don't want to prosecute these two. Drop these charges. We're not interested in prosecuting these 2 men. Please drop the charges. And that failed as well.
Yeah, that's insane. So but the good news is, right, that one hung jury, so I guess it's yet to be determined what's going on. New city council, new city staff. So in your opinion, is the city running better, at least with respect to their hearings and their public hearings, as opposed to back then?
Yeah, absolutely. And not only that, but I had the mayor and at least one city councilman willing to come and testify for me. I didn't end up using them and I let them go. But at least they were willing to come and testify for me because they were there at the time. They just weren't in positions that they're in today. And I think if they retry this case based on everything, it's obviously malicious. And I do plan to go after that county attorney for malicious prosecution. When you get a 5-1, and I've only been doing criminal defense for 3 years. But when you get a 5-1 jury that's not guilty, and then the one that was the holdout verbalizes that she went outside the bounds of jury instructions in order to come to that guilty opinion, if they retry this, that should have been a 6-0. Any other jury that we had on that initial pool that wasn't selected, I think any other juror in there would have voted with the other 5. And so if they go forward with prosecuting me again, it's clearly malicious. And not only that, but I think they're worried because my case should have been easier to prove. The bar for proving a quote disruption is much lower than proving hindering. And there's a reason that hindering a government meeting is a Class A misdemeanor and disrupting a meeting is Class B misdemeanor. They're worried now because if they can't convict me for a lower offense, and Jason did much less than I did. I mean, I used way more profanity than Jason did. There's no way they're going to be able to convict him either. So we'll see what they do with that.
Yeah, I still can't get my head wrapped around how you even disrupt public comment while you're making the public comment. But
right,
we'll have to see. So speaking of your client, there's something else shady that they did, right? You were actually prevented from representing your client during his upcoming trial because I assume, correct me if I'm wrong, because the prosecutor tacked on some kind of conspiracy or law of parties argument. So they said you were conflicted So they wanted to, I guess, hope that they convicted you, and then they were going to use it against your client by saying this was somehow a conspiracy.
Yeah, and nowhere in the information and the complaint does it say anything about me and Jason working together. Nowhere. Throughout all of the pretrial stuff, keep in mind, we're almost going on 2 years since this happened. And I didn't hear anything about law of parties or that I was going to be responsible for his speech or he was going to be responsible for my speech until we got the draft of the jury charge from the state. I got the draft that he sent, and I saw in here, it says, if you find that CJ Grisham alone or in conjunction or in concert with Jason Followin, I was like, whoa, what? How am I supposed to defend against this now? Here we are getting ready to go to trial on Monday. I was never put on notice that I was going to have to defend Jason's speech, just my own. And so, yeah, they tried this law of parties argument, and the law of parties argument failed. I mean, I went on the stand. I did everything wrong. They say you should never represent yourself in a criminal trial because only a fool has himself for an attorney. So not only did I do that, and it just showed that a fool can win this case, but not only did I do that, but I put myself on the stand and took the stand as a witness, which is also something a lot of times you don't do with the defendant because, the state can then go after you for stuff.
So your conduct was during public meeting. You were just simply reading the exact language from Supreme Court cases. These are words that jurists, that justices had wrote, and you were just speaking them. They're words that anybody in the entire world can go pull off, and that's what you were essentially charged with. So let me ask you this. For anybody watching that may want to engage in similar conduct, right? Read opinions or take advantage of the public comment time during open meetings, right, in Texas. Is there any advice you could give them that would hopefully protect them or prevent? Again, none of this is legal advice, but just generally speaking, that would prevent them from being subjected to this similar type of malicious or retaliatory prosecution?
Yeah, so there's, first of all, no one understand the Open Meetings Act, and no one understand what the rules are in the city council. When it comes to speech, I mean, you can say just about anything you want. You can't use fighting words, and fighting words. When you're just talking from the pulpit, the only way that you could possibly. I don't even think fighting words should be one of those things that's accepted because different people are easily triggered, to fight. And so I think even that's a very subjective word. But the bottom line is if you want to prevent yourself from getting arrested, the first thing you do is you make sure you're not speaking outside your time. Make sure that you know how much time you have left. If 1 second has expired of your term, no matter where you are, shut up. You're done. That's it. It's no longer your time. It's now the city's time. Now, a lot of cities, what they will do, and if you go back and watch the Aransas Pass meeting from this past Monday, and it is on YouTube on their city council, you'll see that my time was up. And I politely said, with all due respect, may I ask for another minute? In the rules of decorum, generally there is a provision that allows you to request additional time, and there are different provisions for which that can be approved. It might just be the mayor that approves it. Sometimes it requires a majority vote of the council. And so you can ask, say, with all due respect, may I request an extra minute? If they say no, sit down, you're done. Don't say another word. Don't even start talking on your way back to the seat, because that could be considered disruptive once your time is up. If your time is not up and they're telling you to shut up and they're up there with police officers next to you, just the fact that a police officer's there trying to escort you means nothing. You don't have to voluntarily go with a police officer. You have no duty to do that. But if he says, I will arrest you if you don't leave the podium, leave. Stop. You're done. Being
I just yeah,
There you are. Yeah.
Okay. That was interesting. I think we're good.
Okay. Wait, did I leave or did you leave?
No, I saw it. I don't know, but you're back now, and I think we have everybody here.
Okay. I don't even know where I left off, but
yeah. So the key thing you were talking about was right, like if they threaten to arrest you, you leave, right, and that makes sense because the goal is to not fight these things there with the officer, right, but to fight them in court. That gives you the best chance to overcome qualified immunity, right?
Yes, and legally, if someone asks you to be quiet and you just voluntarily, even though you don't have to, you just shut your mouth, you don't have a case because you voluntarily surrendered your right to speak, right? But if they threaten you with arrest, legally and functionally, that serves as an arrest in and of itself, because the only reason you are not arrested is because you were forced to surrender your speech. And so if you agree that, okay, under threat of arrest, I'm going to sit down or I'm going to not exercise my rights because I don't want to be arrested for exercising my rights, legally and functionally, that serves the exact same purpose. It's no different than if they had thrown you in jail. It's an arrest.
So that's the key thing for Texas viewers, right? And if you're outside of Texas, you need to check your jurisdiction. But in Texas, you could have an unlawful arrest turn lawful if they construe you as resisting, right? Because the law here in Texas is that resisting, you're not resisting even an unlawful arrest is not a defense. And I will tell you, I have had a lot of cases thrown out because somebody is physically resisting. So if you take the arrest or you leave when they tell you to, it puts you on a much better footing to challenge that conduct in court later without creating these messy facts. So,
and you've seen it as much as I have, Brandon, and I love being on your show because you were my mentor and you were also my attorney before I was an attorney. So
appreciate that.
I have seen way too many activists who turn what could have been a great case into a loss because they just didn't shut up and leave. They kept fighting. You don't need to fight. The minute that you're threatened with arrest, you're done. That's it. Just give in. That's all you need. And whether they arrest you or let you go, your rights have been violated. Move on. So that's very important.
So we just got a $2 super chat from HBO Matt. Said, fun when my two lawyers are in one spot. Obviously, in the disclaimer, that is not a retainer. But yeah, so that's no, so that's sound advice. And then obviously let me ask you just point blank, rules of decorum, generally speaking, constitutional or not?
Well, generally speaking, they're constitutional. They're also statutory. If you look also at 007, it says that a government entity can create reasonable rules. For example, time length and stuff like that. If you've got an interpreter, you're allowed to have extra time because you don't speak the language, and so you almost get double the time. They can create rules about limiting comments to just things that are on the agenda. So as long as the rules are reasonable, and reasonable must be constitutional, they're allowed to create rules of decorum. That's why I didn't argue against all of them. I've only argued against the personal affronts and the profanity that are included in all of these, because all of these municipalities are using the Texas Municipal League's model rules of decorum. And there's this
profanity.
Right.
So let's talk about that specifically.
Yeah.
Would you say constitutional or not? If there's
It's
rules of decorum, unconstitutional.
Yes.
So should we, and I know specific to this Aransas Pass, right? That's where this was at, this trial. Yeah. So I also understand that you brought a lawsuit, right, for their conduct, civil rights lawsuit.
Right.
I haven't seen any of the pleadings yet. I know you're going to send those, but are you?
I'm sorry, I didn't send that, did I?
Yeah, no worries though. No worries. I got the person involved in the lawsuit here, right? Are you? Is there a like a? Are you facially challenging the decorum rules in that lawsuit? Or are you looking for a? Are you looking at that at all? Especially as you see these things pop up.
Yeah, we did facially challenge them. And not only that, but we were suing in Jason's case. We were suing on several different grounds. We were doing defamation because they were telling the newspaper that Jason had threatened to kill members of the city council. That wasn't true. We sued them for Fourth Amendment violations for conducting warrantless searches. We sued them for retaliation for sending out these cease and desist letters, and then also for the criminal trespasses and all of that. Now, I'll admit that I think Jason's case was like my first case. I'd only been an attorney for maybe 6 months when I filed that case, and I screwed up and only sued them in their official capacity. So the only thing that survived the initial 12B6 was the First Amendment challenge on the rules of decorum. And the judge denied. He saw it on our side that, look, you guys haven't proven that these rules of decorum are limited to unprotected speech like fighting words or obscenity. And so therefore, no, you're not going to get qualified immunity and you're not going to get this case dismissed. So yeah, we are challenging them on their face.
So that's a pretty, you say screw up, but you are keeping the city in, and on these civil rights cases, keeping the city in is a pretty difficult thing. But not only that, when you get something like that on a First Amendment challenge against the city, you have the chance to basically lay the foundation to clearly establish that issue across not only the state, but across the Fifth Circuit. So right. I wouldn't say that's a screw up. That's still a very big deal, right?
Well, and I think the reason I say screw up is because Jason has so many damages the whole point of him getting in there and cursing the way he was because he'd been going through 2 years of corruption and tyranny where they were raiding his business for no reason. They were charging him with things that literally the chief of police had the exact same so-called code violations, but they weren't code violations. There was so much going on when you've got the city just pulling the hammer down on you. He did a protest, and during his peaceful protest, the city brought in snipers and had them on buildings surrounding all the protesters.
What?
Yeah. So, that's kind of why I'm a little upset, because we did lose a lot of his damages and we're limited to just the First Amendment issue. But at least when we get to a jury, and I can say we did have mediation. Mediation failed, which means we are moving forward with a trial. But I did just file this morning a motion to stay proceedings because I want Jason's. We thought that by the mediation, Jason's criminal case would have already been done because it was supposed to be done a week and a half ago. And since it's not, I want that not guilty verdict for Jason when we go to a jury trial.
So his is a misdemeanor, right? So there's still, you get that not guilty, right? That's going to open the door up. Obviously, not legal advice. Haven't seen everything, but obviously you would know. Malicious prosecution, which for viewers who aren't aware of this, for the longest time in the Fifth Circuit, malicious prosecution was not a valid claim under the Civil Rights Act until the Supreme Court decided the issue. I want to say in 2022 or 2023. So malicious prosecution is now a valid claim to bring. And the statute obviously doesn't start running until there's some kind of finding of innocence, whether through dismissal or a jury finding. So just keep that in mind. We did get some more super chats. HBO Matt looks like again, LSB Productions. I appreciate that. So HBO Matt, it looks like he's having issues with Corpus Christi rules of decorum. So,
and I've sent in a demand letter into Corpus Christi based on. They also have so Corpus Christi goes even further. If you are not a citizen of Corpus Christi, you can only speak for 1 minute. If you're a citizen, you get 3 minutes.
Yeah, that is that doesn't sound reasonable at all. Actually,
it's not. The courts have already determined what is the public when it comes to the Open Meetings Act. And the Texas Supreme Court has said quite clearly that the public is the people. It's anyone that is not sitting up there on that government entity.
Right.
And it doesn't say citizen of the city. It doesn't say, but it says that members of the public have the right to address the city council. And you know, and it makes sense because when you and I drive to Corpus Christi, we're just as subject to the laws. We're just as subject to all the government officials. We're just as subject to all the rules as anybody else. But if a police officer violates my rights, according to Corpus Christi, if I'm not from Corpus Christi, but I happen to be visiting and putting my hard-earned money into the economy, I can only complain about that for 1 minute, but a citizen's allowed to complain about it for 3 minutes. So that's a blatant and facial violation as well.
That's a huge issue. I had no idea, actually, because you think about it, it's just like the Texas Public Information Act, right? I can request information. Matter of fact, anybody in the world, it can request information from any Texas government entity under that act. They can't say, well, hold on, where do you live? No, that's not part of the equation. The idea is to be transparent, right? So same situation here. You're not transparent if you're deciding who gets to speak when, right? Especially if it's not consistent. So that's I definitely would have a problem with that. Now, I do want to, unless you want to talk anything else on this, I do want to shift gears a little bit and talk about memes, right? So
yeah,
because you're talking, because let's be frank, we're talking about First Amendment comments, especially against government officials or whatever. And what was in the news recently was, let me pull this up. I'm sure you all heard about this. It was in Tennessee. I'm going to play this article and we can talk about it real quick. Up. I'm going to back it up.
For some reason, I can't hear that, but it's fine. I can put it on my other screen.
Oh, I had it muted.
One day after an exclusive News Channel 5 investigation raised questions about this case. Thanks for being with us. I'm Rory Johnston.
And I'm Carrie Sharp. We shared that story last night right here at 6. And now prosecutors dropped those charges against Larry Bushart today as our chief investigative reporter, Phil Williams, was continuing to dig up new information.
This all went down suddenly today in Perry County, southeast of
Put
Nashville.
in the chat if y'all have heard about this story.
Was there when Bushart walked out of jail after 37 days behind bars.
How do you feel right?
So, 37 days in jail for a meme. Let me just, that's insane. Okay.
We have just gotten to the point, like, we have lost our country. I mean, when we're throwing people in jail for words and memes, I mean, can you imagine, could you look back at the pamphlets from the 18th century that were put out there? Those were essentially 18th century memes, was a lot of the sort of cartoons and things that were done way back in the day. They're just digitized now.
So I'm gonna keep playing it, but I missed that the first time around. The 37 days. That's just insane.
Thanks to all and any supporters out there, and very happy to be going home. I didn't seek to be a media sensation, but here we are. But yeah, that's about all I can say right now.
Now, Phil, you spoke to Mr. Bushart's wife shortly after those charges were dropped. What did she have to say?
Yeah, that's right. She was on her way from her home in Lexington to pick up her husband at the Perry County Jail, and needless to say, she was ecstatic. She says she believes it was our interview with Perry County Sheriff Nick Weems that changed everything. That's the meme that he posted, correct?
That looks like it, except.
So I want to highlight as well that the charges weren't dropped until the media got involved, right? So if there was no awareness about this guy would probably still be sitting in jail. I just wanted to make that comment because that was some BS. Someone put in the comment, $2 million bond as well. I hope this guy, if he hasn't already, sues the dog crap out of them. And after this, I'm going to show you a case. If this happened in the Fifth Circuit, what would happen?
This part was blurred out, the face.
This is the meme at the center of the controversy. A quote from Donald Trump, "We have to get over it," which the image notes was what the president said about the Perry High School mass shooting one day after, a reference to a tragedy in Perry, Iowa. But Larry Bussart was arrested last month and locked up on a $2 million bond after some in the community somehow claimed it was a threat to shoot up Perry County High School.
That led people to believe in our county that he's talking about Perry County High School, because it doesn't say Iowa either.
But you also knew this was an existing meme that was already out there on the internet.
Correct.
Knew it.
And so it's clear he's not talking about Perry County High School.
We knew. The public did not know.
Sheriff Weems had also told us that Perry County asked local police in Bussart's hometown of Lexington to go talk to him, let him know the fear his post was causing, and ask him to take it down, and that Bussart had refused.
You know, parents just want to send their kids to school without being afraid that they'll get shot. I mean, what kind of person does that?
People just don't want their rights violated.
Says he don't care.
He sits there and says we knew, the public did not know. Well, you're the one that arrested him.
Perry County investigator. They want to
and you just admitted that you knew it.
Okay.
But
and you arrested him anyway.
Investigators had just obtained this video from that encounter a few hours before Bussart's arrest, and the Lexington police officer seemed to have no idea why a Perry County investigator had asked police to pay a visit to the progressive Facebook warrior.
He had just called me and said that there was some concerning posts that were made on
Facebook.
On Facebook, yes, sir.
And they said you guys.
They did. They wanted me to come make contact with you and let you know that they may be in contact with you and see if you still live here. I don't know exactly what they're referring to.
I knew. Charlie Kirk.
Well, I don't know.
Bussart had posted the meme to suggest people were more concerned about Charlie Kirk's murder than they were about school shootings. But the video shows the officer never mentioned any concerns about a school.
They said that something was insinuating violence.
No, it wasn't.
And like I said,
I'm not going to take it down. Go look.
I don't care. This ain't got nothing to do with me.
You got that rolling. Okay.
Yes, sir.
And Mr. Bussart's wife told me she planned to take her husband out for a nice dinner tonight since he's been eating jail food for the last 37 days. Unfortunately, because of all of this, he has lost his job as a medical driver. This is probably not the last we're going to hear of this story.
Any reaction from Sheriff Weems on all of this today?
You know, nothing official yet, but listen, you have to hand it to him because I asked him to sit down and answer my questions. He certainly didn't have to, you know, but we ended up with a situation with a result that a lot of people are now applauding.
That's exactly what I mentioned to you yesterday. I said, pretty impressive that he's doing the interview.
Give him credit for that.
That's exactly right. Thank you, Phil. Now, if you want to watch the
So 37 days, whatever, $2 million bond charges, because even though they knew that it was a meme that's been circulating, they decided to go after him. Absurd. How did this not get in front of a magistrate immediately? Or if it did, how did that clear the prosecutor? Like, I have a lot of questions.
I think you know as well as I do, Brandon, you've been doing this longer than I have. The system is broke because we've got people in jail and you've got magistrates who will set bond amounts based on nothing more than the charge. Not on probable cause, not on whether it's even possible that they did what they did or that what they're accused of doing is even legal. Oh, okay. Let's see, exploitation of the elderly. All right, that's a $15,000 bond. Assault on a peace officer, $20,000 bond. Like, they don't even look and see what are they alleging is the assault or what are they alleging is the exploitation of the elderly. So it fails from the get-go where people should just be immediately released. They're being magistrated and bonded and let the courts deal with it, and then you've got the prosecutors who do it anyway, who file these charges knowing that they shouldn't be filing these charges. and it fails there. And meanwhile, this person's got to drop bonds, thousands of dollars sometimes, that they're never going to get back. What's that?
Lost his job away from his family.
Right.
Right. I mean, nobody really like if you haven't been in jail before, or you haven't tried to put yourself locked away from civilization, you know, that there's some big issues with that I don't know if people truly understand what that does to a person.
You know, and I got
over
accused,
a meme.
Yeah. You know, I got accused during the trial. Apparently I'm a money hungry attorney who looks for ways to sue. You know, the whole reason I went down there to Aransas Pass was because I wanted to file a lawsuit. You know, what's interesting is the state can do anything they want to you. They can steal your freedom. They can steal your money. They can steal your reputation by just making accusations against you that are bogus. All we have, well, I won't get into what the Second Amendment was for, but all we have is the Civil Rights Court. That's it.
Well, and obviously I have my issues, and you're well aware of those, right? Because we did that case together for a number of years. And so, yeah, but you're exactly right. Here's the thing. When I hear that phrase, oh, you're just looking for a lawsuit. No, I'm looking for you to do the right thing, right? Because if the idea of cameras and social media and being able to talk about these things and share these stories, at the end of the day, it's about two things: doing the right thing and accountability. That's it.
Exactly. And let me ask you this, Brandon. If you were in this for the money, and I'm writing something down here because I don't want anybody to think I'm, that I'm just agreeing with you. If you were an attorney and you just wanted to get rich as a civil attorney, what type of law would you be in right now?
Personal injury. Yep, that's right. And if anybody knows, right, because I'm sure they've reached out to you just like they reach out to me, there are not a lot of lawyers across the country who touch civil rights cases. And there's a reason for that, because it's such a high bar to get over qualified immunity, sovereign immunity, all these other immunity issues. And then even when you do it, so take, for example, if you sue successfully a city under, it's called Manel, you can't get punitives. You cannot get punitive damages against them. You could get it against the individual officers, but the insurance company isn't going to cover that. And then you go to the city's not going to cover it. So who are you getting punitives against? People who can't afford it.
Yeah.
And that's after several years of litigation. So I don't know any lawyer who's going to be like, oh yeah, I want to make money and go do this. I mean, it's not every case. Most cases are not going to be successful. I want a Rolls
Royce in my own airplane. I'm going to go into First and Second Amendment law. Yeah, that's what I'll do, because all the First and Second Amendment lawyers are rolling in the dough, right?
Yeah. You know what's easy though, right? The lawsuits that are easy are the ones where the government officials or government employees make it easy because they do stupid shit, right? Yep. Like locking you up for 37 days over a shared meme, right? Or charging you for disrupting a meeting because you read Supreme Court cases. I mean, they're the ones making it easy. They're the ones who should be held accountable for it, right? Yeah. But now look, take your case, for example. You're in a situation where not only did you have to deal with the criminal piece, your client had to deal with the criminal piece. You had to deal with this for how over a year now, and then it's still not over. Almost 2 years, and it's still not over. Because apparently, according to them, this is what you wanted. Can you believe that? Is that...
I went there to try and prevent future damages, and they just created more.
Yeah, that's nuts. Yeah, I mean, I'm sure, CJ, I am convinced that every time you go to these city council meetings, you leave that house and you're like, hey, wife, kids, I can't wait to get arrested today.
Right.
Because lawsuits, right? Like, where do they get that from?
Well, and it's twofold, because not only do I make sure, and my wife worries about me all the time because I've got 5 false arrests under my belt. And she worries every time I leave the house to go to a city council meeting or to go down to a some kind of board meeting for the education board. And she's always like, please don't get arrested. I'm like, babe, I'm not going there to do anything to get arrested. All I'm doing is I'm reading them case law. We're fine. It's not going to be a problem. Not only do I not go there, but I mean, my family worries about me every time I leave the house to go and do any type of activism. We had an open carry rally yesterday, and I had to make sure that I texted my wife on a regular basis so she knew I'm not in jail for exercising my rights. I mean, that's a sad commentary on where we are as a state and a country.
Yeah, that's insane. So if this meme situation, so one of the things you mentioned, one of the Supreme Court cases you cited you talked about, the case was talking about cuss words, profanity cannot be used as probable cause. Well, so for anyone that, matter of fact, I think this would actually be case law across the country. It would be clearly established across the country because it's from Supreme Court cases. But this meme issue, before your incident and before this Tennessee incident, the Fifth Circuit actually had already decided this issue, and it was the Bailey v. Isles or Illis matter here. And matter of fact, it was decided back in 2023, and there was actually an en banc hearing. And for those of you who don't know, when you appeal something to the appellate court, it's generally presented to 3. There could be 15, 18, 21 appellate judges in any given time. And the way they do it is they divvy up the cases 3 at a time. So when you see en banc, that means that the whole panel took the case up and they considered it, right? Or a majority of the panel. So that's what you're seeing here. So in this case here, the issue, of course, was a meme. So Bailey filed a civil rights lawsuit saying First and Fourth Amendment rights were violated when he was arrested for a terroristic threat on Facebook. Now, keep in mind, this was during COVID, right? So he lived in Louisiana back in 2020 during the first month, right, with all the lockdown crap. He posted, again, right? I don't even know if he actually made this or he was just sharing what other people were doing, saying that Rapids or Rapids or whatever this is, Parish Sheriff's Office issued the order if deputies come into contact with infected, shoot on sight. Lord have mercy on us all. Now, terroristic threat, who's the threat against?
Yeah, I don't see it. I mean, really the threat's against the so-called infected. It looks like he's saying that the deputies are going to shoot the infected people.
And then look at the hashtag as well, right? Context matters. It says, we need you, Brad Pitt, right? From, I guess, the movie Z. So he obviously intended it to be a joke. And of course, the court referenced the hashtag, or World War Z. That was so that's the first thing the court, right? When the court puts things front and center, they're telling you that's what they find important.
Yep.
So in his post was in response to another friend who's joking about COVID, and everybody understood it to be a joke. But after he posted it, the Detective Isles was assigned by the sheriff's office to investigate his meme to see if it was a legitimate threat.
Can you imagine? I mean, coming from a law enforcement background, and for those who don't know, right there, that's my retired badge and credentials right there. You can't see it too well, but that's my retired badge and credentials. Someone came to me and said, "Hey, Sergeant Grisham, I need you to go. This guy did this meme. I need you to go investigate whether it's a legitimate threat." I would say, wait, I'm going to investigate a meme? Yes. Okay, sir, I just investigated. There's no threat. It's a meme. Like, I wouldn't even move.
Can you imagine? So here's the issue. Like, we're in 2025, almost 2026. The amount of memes that I see on a daily basis getting posted, do they really devote taxpayer time to paying these guys to going through all of these things?
look, we just had a guy locally that the FBI visited as well as DPS because he put on Twitter, and I mean locally, like in my town, because he put on Twitter that he thinks that all Jews need to be eradicated from the planet. I mean, it's real.
Yeah. So then you look, right? So the detective testified in deposition that he thought the post was meant to get police officers hurt. This is a common thing I see in cases, okay? The amount of fear that these officers allegedly have, right? With anything. Just the general sentiment that everyone wants to hurt police officers. There's no specific instance. They're just talking about generally that they think every day they're going out in the street. Apparently they're in a war zone. I don't know where they're getting that. So he looked at the posts and comments and concluded that Bailey had committed terrorizing in violation of state law. So what did they do? So what did they do about that? Right? Here's where it gets crazier. Without seeking an arrest warrant, they went to his house and arrested him. He was in his garage, and a dozen deputies with bulletproof vests, weapons drawn, ordering him to put his hands on his head, on his knees, and they handcuffed him. They sent the whole sheriff's department and raided his house without a warrant. Have y'all heard this story?
And I love that what they told him when they were handcuffing him.
Yeah, next thing you put on Facebook should be not to fuck with the police. And then they laughed, right? Well, who's laughing now?
Yeah.
So he, of course, was charged with it. And eventually he deleted. They got him to delete. They told him if he could delete it, or they would contact Facebook to remove it. And then they later filled out an affidavit for probable cause arresting without a warrant. And so they basically wrote in the affidavit, this is, cops always lie. I shouldn't say that. Generally, or in my experience.
Cops always lie.
Yeah. In my experience, cops lie more often than not. So what did they put in the affidavit? The suspect put a Facebook post that the sheriff's office had an order to shoot on site due to COVID breakout, arrested without incident. And that the criminal based solely on the words of the post itself and not on anything Bailey had told him. So they arrested, and then of course they announced the arrest on their own Facebook page. But what ended up happening? The district attorney, probably smart, dropped the charges and said, we're not going to do this. So normally when things go up on appeal, right, that means the case probably got dismissed. Well, as you can see here, there was a summary judgment. The district court granted the defendant's motion and dismissed Bailey's claims with prejudice.
Wow.
So that means essentially that the district court likely found that it was not clearly established that Bailey's post, that them arresting him without a warrant for his posts didn't violate clearly established law. It took the whole panel of the Fifth Circuit to say, we need to look at this.
That's crazy. These people are judges.
Right. So the court then went through the qualified immunity aspect, right? So the big thing that we always see in these cases is clearly established prong, right? It basically has to be, did the cops have sufficient notice? And so the central concept that they always look at is there fair warning? There has to be prior decisions that give reasonable warning that the conduct was at issue. That's the issue that's the issue I always complain about, right? If these courts aren't ever, right, it's two prongs. The first prong, was there an actual constitutional violation? The second prong, was the conduct creating that violation clearly established? The Supreme Court says that courts can start with any prong. So if they always go to the second prong, that it wasn't clearly established, and they never answer the first prong, then if this issue happens over and over and over again, and no one ever answers the question, does it violate a right? Then it never gets clearly established, and the case just keeps getting getting dismissed.
Yep.
Fortunately for Bailey, he had the same cases that you had, CJ, that you were reading, right? First issue, anytime you're looking at a First Amendment issue, you have to look at, was there protected speech, right? So, and here's the kicker. The Fifth Circuit did this sua sponte, meaning they did it themselves. They said, hey, no one actually questioned whether the speech was protected. And so they basically said, right, that it was, the district court concluded that the post was not constitutionally protected because it created clear and present danger. So a post about infected, shoot on sight, misinformation. Who gets to judge misinformation during the early stages? And so said it was similar to shouting fire in a crowded theater.
And I don't know if a lot of people know, Schenck was actually overturned. We keep hearing this all the time. Oh, you can't shout fire in a crowded theater. Schenck was overturned.
I did not know that. I'll have to look that up. But no, it would make sense. I mean, but thankfully the Fifth Circuit said, yeah, that was error, right? So they went and said, hey, look, social media posts, right? Well, CJ, that it's very limited to what actually is restricted under the First Amendment. And we start with this broad idea that messages, ideas, subject matter, content, it's usually protected, right? Where the government has no power to restrict these things. And so these protections apply to jokes, parodies, satire, whether clever or in poor taste. So the comments you talked about, hating Jews or whatever that post was, even if it's viewed in poor taste, it's still protected by the First Amendment, because the idea in our country is that the government is not supposed to be the decider of the message that's being had in the open space, right? We as people should be able to understand that. So the First Amendment does not protect all speech, right? And they limit it to certain things, which you brought up, I believe, right? And so the first thing they talk about is incitement. They give a whole section about clear and present. It's got to be immediate, right? Like immediate incitement.
Exactly.
And then
you can't say something like, let's just go back to what I was just talking about. Like, all Jews should be eradicated from the planet, that person tweeted. That's not, there's nothing imminent about that. It's sort of a wishful thinking on his part. But yet you've got people going in there trying to say it's incitement. Well, only if immediately after that, a bunch of people went and eradicated all those people off the planet.
Yep. Nope, that's right. And so the Fifth Circuit obviously talks about the Brandenburg case, really big Supreme Court case, which involved broadcasting a film of a KKK rally, right? And so what ended up happening from that was that it did not meet Brandenburg's requirements. Basically, let me see. The court reversed the speaker's conviction in that case because it did not distinguish mere advocacy, right? Mere advocacy from incitement to imminent lawless action. So if you're just merely advocating for something, even if in poor taste, it should be protected by the First Amendment, according to what this case is saying. And they're citing to Supreme Court case law that's been around for a while. So Supreme Court,
and I like that they quoted Hess.
Yeah. So Supreme Court precedent. So when you're talking about clearly established, right, this is what you want to look for. The post was not advocacy directed to inciting or producing imminent lawless action, nor likely to incite such action. So that's the key thing. Is it directed to incite or produce imminent? Imminent means immediate, like right now, lawless action, right? Like how many posts over the last couple of years have there been? Oh, there's gonna be a civil war or 2A this, 2A that. I just lost CJ again. Someone said earlier he got ET'd. Did he just get ET'd again? CJ, all right. I'm gonna keep going through the case. Let's see if let's see if he gets back in. All right. So I'm going to keep moving on. Yeah. Someone just said, Dwayne, that's right. As Otto says. I mean, I tell you what, I did not know about Otto. His stuff was pretty good. And I do love his sign that says shit is all fucked up and stuff. Matter of fact, I may play a portion of that because he just posted recently a video where he got a ticket in Winsboro, and it was under the building code. They couldn't actually find the ordinance for his sign. So let me see. Let me just double check before I move on. Okay. Yeah. If hey, let me tell you real quick about my channel. I've been, I think I posted my first video a couple of weeks ago. Already almost up to 10,000 subscribers. I thought it was going to be a situation where I was probably just going to post some informational videos or just kind of point out some absurdities. But the support and the views, subscriptions, or however all that YouTube stuff works, I definitely appreciate it. I thank you all. And maybe I should keep doing this. I didn't think I would still be doing this today, believe it or not, even though it's not even a month in. But that's how short-sighted I was with it. I see everything people do on YouTube, and I'm like, oh yeah, this is going to go pretty quick. I know a lot of people put a lot of time and effort into it, and I'm not a tech guy dealing with all that crap. It's just, CJ just said someone just hit our power pole and took out the internet. So I'm going to keep moving without him. But yeah, and then appreciate Luger the sticker, and then let me just go through these. Yeah, addicted. I do like sharing. Here's the thing. I nerd out, and my wife will tell you this, and my friends will tell you this. I nerd out on civil rights stuff. I mean, if you saw my last video, I talked about an article I wrote. Matter of fact, I still have it here. Talk about an article I wrote in 2016. I got published for a law review article about Fourth Amendment violations before I even became a practicing attorney, right? So the law and making sure people follow the law is very important. A little bit about me real quick. I joined the Army at 17 years old. So my moral compass was about, fighting for something bigger than me, fighting for my brothers and sisters next to me. And when I saw people not do the right thing, or I saw the system do the wrong thing, there's something inside of me that says, I'm not going to stand for that. And I wanted to be a lawyer to advocate and make that change. And there's some cases where, we didn't get the result I wanted. Judges don't always see things the way I expect them to be. But that doesn't mean I stop fighting. I'm going to keep fighting. So, but anyway, let me keep going on this case, because this Bailey case, this is important, because even if you're not in Texas or the Fifth Circuit, you can use the case law in this case. Why? They cite to the U.S. Supreme Court. That's binding across all states. So CJ was talking about the Hess case. So it was about Hess v. Indiana. The court reversed the disorderly conduct conviction of a Vietnam War protester who said, we'll take the fucking street later. And of course, they arrested him but they said it didn't hold up because it was not directed at any person or group. He said, what do you say? He does what Otto does, fuck bad cops, right? We'll take the fucking street later. Who are you directing it at? Or is it imminent, right? That's the other thing. Even if it was directed at someone, there still needs to be imminent unlawful action. So Let me tell CJ real quick. If it comes back, same link. Why no Starlink? Chat says, shut up. I shouldn't comment on that. Okay. So what the Fifth Circuit did, they went through all the Supreme Court case law that basically says this is what you're looking at here. He says he has Starlink, but no power, so he's dealing with that right now. But that's what they did. So they went through multiple pages to say it's not imminent. Here's all the Supreme Court case law. Then what did they do? They hit the second thing. Let's talk about true threats. In order to be terrorizing, it has to be a true threat, which means that the statements where the speaker means to communicate serious expression of intent to commit an act of unlawful violence to a particular individual or group of individuals. And the context for this analysis is critical. So what they say, just looking at the post itself, it's not a threat, right? Because it's not directed to, so they couldn't figure out who it was directed to. Is it to the public? Is it the deputies? They don't know. So if they don't know, it not only that, but it lacked believability and was not serious. And what did they do? They looked at the hashtag. Hashtags are important, right? This case proves it because of the calls for rescue by Brad Pitt. So that's twice the court referenced the Brad Pitt thing, right? So CJ, if you're watching this on your phone, you probably see the comments. They're telling you to fire up your generator. We all know you got one, all right? So, and then they cite to a U.S. Supreme Court, more Supreme Court cases, right? So the First Amendment claim we know is good because the post did not cite specific harm, and it doesn't matter if there were complaints. It doesn't matter. That's not part of the equation, right? People can complain about what you talk about all the time. So now you look at the Fourth Amendment claim, right? The issue here was that the district court determined there was probable cause to arrest him for the terroristic threats. Well, the Fifth Circuit said, nah, you're wrong. Why? Because they went through what the statute was. It says terrorizing is intentional communication. The commission of a crime of violence is imminent or in progress, right? So they break it down. That's what the Fifth Circuit does. That's what these courts do anytime there's probable cause analysis, which you'll always have for Fourth Amendment. They're always going to break down the statute. So that's why it's critical, right? There's a lot of people who talk about, Texas is famous for the failure to identify, right? If you don't identify, I'm going to arrest you. Well, if they read the actual statute, it says you only need to identify, right? If you're under a lawful arrest. I'm not talking about the recent amendment for drivers, but let's just talk about every other circumstance. So if you're not under arrest and you're not pulled over for a traffic violation, you don't have to identify. And so to determine if there's probable cause for that, the court's going to do a very similar analysis. They're going to look at the statute and they're going to say, you obviously didn't meet these elements. Why? Because they weren't under arrest to begin with. So then they look at some Louisiana cases here, breaking down that specific statute. And so that's what they do. And then after they get through everything, they basically break it down, right? Because probable cause is about totality of circumstances. So what is known and does it fit into any of the elements? Well, here, the relevant facts and circumstances known to the defendant officer at the time of arrest. That's important, right? It doesn't matter what the actual facts were for a Fourth Amendment evaluation. It matters what information the officers actually had. So when I represent auditors or people who video police or do whatever, and cops go back and they didn't know about you and they go and they watch your video and they're like, oh, you plan to do this, they're going to try to make that an issue. But the reality is they can't, because they didn't know it at the time they made the arrest. And even if they did want to make it an issue, I think it opens up a whole bunch of other issues. But right, that's what they're going to say. Oh, you're just posting this. You said you were going to go and try to agitate or try to film this for we know you make money from this, and that's why you're doing this. Okay, but at the time you decided to make that arrest, what did you know? Well, they didn't know shit. So, and the court's going to catch that out. So, January 6th protests. Now that was the experience. Oh man, Lisa, you said that in the open. I'd be curious, with all the flock camera and other stuff. Interesting. I'm before I get off topic here, I'm going to get off topic. Did y'all see the Blaze article about it was a Capitol police officer that allegedly dropped those pipe bombs? I mean, that is nuts. They could find all these January 6 people, but they couldn't figure out who that was. And it turns out she's a person that was with Capitol Police and then apparently right after that left and went to work for the CIA. I mean, there is so much to that. Man, so much information. But back on this, what did the court do? They looked at the facts. What facts were known to the detective? He was asked to investigate the post. He looked at the content of the post itself. Bailey authored the post. He looked at the comments and then statement to the deputy that he meant the post as a joke. And nobody actually reported it to law enforcement. I don't think that would matter. And then general social conditions during the early onset of COVID. So nothing in there talks about immediate harm or ongoing harm. So in the end, they basically are letting that case go forward. I need to actually go see what's going on in the district court, right? Because what did they do? They said, hey, look, the detective is not entitled to qualified immunity. So there you go. And then the First Amendment claim, the First Amendment retaliation, were you engaged in protected activity? And then were the defendant's actions cause would the defendant's conduct chill a person of ordinary firmness from continuing to engage in that activity? Doesn't mean if they're going to stop you, right? Say you're going to be like, I'm going to film no matter what, or I'm going to engage in this conduct no matter what. It's not the standard. The standard is a normal person of ordinary firmness. Well, raiding their house and arresting them and then charging them with terroristic threat or terrorizing, that would absolutely chill a person of ordinary firmness from wanting to post anything, anywhere, right? So they basically just slammed the district court here. And then here's the key thing, right? Bailey has shown that the detective is not entitled to qualified immunity. Why? Well, based on decades of Supreme Court precedent, it was clearly established that the Facebook post did not fit within one of the narrow categories of unprotected speech. So, to me, that's pretty huge. That is substantial. And actually, what I would say is, when you look at First Amendment cases generally, they seem to create these nuanced things or issues that courts are willing to pay attention to get over qualified immunity. So what the type of case I think that would actually have a really good shot of overcoming qualified immunity or getting the Supreme Court to consider it is probably going to have to be a First Amendment issue like what we see here. So but before I move on, I'm going to go through here, see if there's any questions. You had to take your channel down. Wow. Is that over from the January 6th stuff, Lisa, that had to happen? That's crazy. So another thing I do is and we'll kind of wrap it up after that. But another thing I do is I look up cases that have come out across the country, specific to qualified immunity. So I did want to go through those, and so the first one comes out of the Ninth Circuit, and it's actually this case is pretty heartbreaking. So it came out just this past week out of Nevada, and the bottom line is there was this neighbor. He was upset about a noise complaint that this mother made against him at this apartment complex, and I guess the guy was psycho, off his meds. And so he saw her in the parking lot and he went to attack her. She ran into the house with her daughter, and inside this house was her daughter, her 12-year-old son, and then I guess 2 housekeepers. He went in, immediately shot one of the housekeepers, shot the mother as well, and then of course shot the little girl. And so what ended up happening after that was he then took the boy into the vehicle, the mother's vehicle, and they were sitting there in the parking lot. And there was a lot of back and forth with dispatchers. They were trying to negotiate, but what ended up happening was he kept making these threats, saying he was going to kill the boy, right? And of course, he was pleading for his life. He was pleading for his life that he didn't want to get shot. And so the guy, the bad guy here, would say things like, hey, asked the boy if he wanted to die, announced he was going to shoot him in the brain. But so here's the timeline of where it gets a little crazy. So at 11:24:31, so 31 seconds, Sergeant Smith, who was in charge of SWAT, radioed to the officer and said, "Take the shot if you have it," in the vehicle. Well, he took the shot a couple of seconds later and he killed the bad dude, right? What the heck? Killed the bad dude. Bad dude's down. But what ended up happening, 2 seconds after he took that shot, there was no coordination with the shot. 2 seconds later, the vehicle was surrounded by 16 other police officers. And within seconds of hearing that fatal shot to the bad dude, these guys just riddled the vehicle with that 12-year-old boy, just riddled it with shots, obviously killing him. And unfortunately, what ended up happening was, so the father, right? Father lost his wife, his daughter, and his 12-year-old son. He didn't think the son should have been killed, right? Because if the officers knew that shot, where it came from, they shouldn't have shot. What ended up happening was the appellate court said the officers get qualified immunity for 2 reasons. The first is they're saying there was no seizure under the 4th Amendment because the cops never seized the boy. He was hostage. And then the court then said, even if we were to assume that it was a 4th Amendment seizure, it was not clearly established that officers who take mistaken shots are going to be held liable. So as a result, the officers got qualified immunity in this terrible situation. And of course, because there was no liability, what happened, they sued the city as well, saying your training sucks. You need to do better at handling these situations. Well, it fails because the individual officers were able to escape liability. So as a result, nothing comes from this case, unfortunately. That's good. So that was the Ninth Circuit. That was the same circuit, if you've seen my other videos, where the cops stole that $225,000 executing a search warrant, and the Ninth Circuit said, oh, cops, there's nothing that says cops aren't allowed to take this. They don't know any better. As same circuit here. So also out of the Ninth Circuit, this case published this week, it was a takings. This is also another raid, but this time not in Nevada and California. These officers, LAPD SWAT, fired dozens of tear gas canisters through the walls, doors, roof, windows of the plaintiff's store. Basically caused basically destroyed the store, caused like $60,000 worth of damage. He tried to claim it was a takings clause issue under the Fifth Amendment, and that they owed him for all the damage that they caused. And of course, I'm sure you all know. So here's what's interesting. The reason they took this case is because there's actually a split right now in the across the country. So I think this issue might be heard by the Supreme Court at some point about whether there's a takings clause case. Right. So the Ninth Circuit had not actually decided this issue yet, but other courts, right? So 4 courts, the 4th, 5th, 6th, and federal circuits held there is no categorical police power exception to the takings clause. So in those cases, they basically say you don't get to bring, right, that lawsuit that no compensation is owed. So the Ninth Circuit, California, one of the most liberal circuits, the circuit you would want to be in to let these cases actually overcome qualified immunity, they held here that there's no claim. So of course he lost that one. So now we have a split as to whether or not these types of claims get to go forward. Whether they appeal to Supreme Court, whether Supreme Court takes that, I mean, who knows? But it's just one of those things where you want to see these splits to kind of force the issue to be taken. Hopefully the attorney in that case challenges, right, or challenge the qualified immunity in the first place. And then this case is out of the 10th Circuit here, published this week. Specifically Oklahoma. So what ended up happening was, what was this one? Oh yeah. So Oklahoma police officers, they respond to a domestic disturbance within 4 minutes of arriving. Within 4 minutes of arriving, they shot and killed this guy. And so they brought a claim, excessive force claim. And basically, what did they do? They said, hey, look, the district court denied the officer's summary judgment. So here's what's important. I like this case, bringing these cases to you because it does show that sometimes people are able to bring cases forward. So summary judgment, basically what the officers asked was, hey, we did all this discovery. We don't think this should go to trial. We want you to rule on the evidence and basically decide that there's qualified immunity and that we get off for this. But the district court said that there's facts I can't really weigh. There's credibility issues. There's interpretation of evidence issues. So a jury's going to have to decide that. And some of these issues are so critical that it could turn on whether or not conduct was clearly established or not. So the court basically said they're not going to do that, right? Now, of course, right, this is something from 2019. So again, we're in 2025. You're seeing litigation. But as a result of this, and the guy died, right? His family actually had to bring this lawsuit, but they do get to go to trial. So here's a quick rundown of the facts. They were dispatched to the home, and then when they arrived, they thought he was acting erratically, maybe under the influence, and so they wanted the guy out of the house. The homeowner wanted him out. He was unarmed, but they told him the cop told him if he keeps making furtive movements, So they're concerned. So then Willis Jr. grabbed a key, opened the door, and then walked defendants into the house. Once inside, defendant officers saw that Thomas was sweating profusely and bug-eyed. He did not react to their presence. And as everyone entered the house, it was clear Thomas was holding an innocuous object. And so they immediately told him to drop it. And then at the same time, the officer pointed his taser at him. And then without further commands, just tased him. So they took the taser out. They didn't give him any commands and just tasered him. And then while that's happening, another officer unholstered and drew her service weapon. Now, keep in mind, at this point, the dude is getting tasered. He's walking backwards into a bedroom, lies on the ground, but then stood back up. And then he gets tased again. And then when the taser failed to incapacitate him due to user error, there was a brief skirmish. And so this is all according to the report, right? So at some point, Thomas was killed. They killed him. So the court looks, they evaluate what are the facts. If there's a blatant contradiction in the facts, the court cannot resolve it. That's for the jury. So let me see here. So that's what they do. They basically look at all the information. They go through it. They talk about the fact that he's unarmed, right? Like deadly force is a whole other element for qualified immunity analysis. So the court is basically saying, hey, there's enough issues here about whether or not the officers should have used deadly force given the scenario. So in the end, they talk about excessive force. I'm actually going to be releasing a video on excessive force, so I'm not going to get too much in detail here about it. But it's basically the Graham factors, right? So the first thing courts look at. So the great thing about excessive force, well, there's nothing great about excessive force, but the great thing for qualified immunity in excessive force is you look at the severity of the crime at issue, right? So the severity, so there's all these factors. So essentially, you don't have to pin it into a specific case, right? You basically look at the officer's conduct tied with these four factors, and it doesn't matter what it is, you might be able to prevail on excessive force. You don't have to find a case on point because the courts typically say that these factors, officers should know whether the force was appropriate. And so one of the things, and that's why these factors might preclude summary judgment and might give you a chance to go to trial because there might be an issue on some of these things. Severity of the crime, for example, that's not really an issue. Everyone's going to know were the cops there for a felony issue, a misdemeanor issue, right? Was it a failure to identify versus a murder or a bank robbery? Those things are important. 2, whether the suspect poses an immediate threat to the safety of the officers or others. So if they knew he wasn't armed, right, or if he was armed, right, that changes the calculus. So that might be a question for a jury. What is it? What do they believe that the officers understood about the suspect? And then another thing, whether he was actively or actively resisting, which is different from passive resisting. And then another thing, or attempting to evade arrest by flight. So for deadly force, the issue is the precise time of the shooting. And then an earlier facts and circumstances will be important as to whether or not the deadly force was reasonable. And so the court's going to go through its analysis and basically say there's all these arguments, all these issues. And as a result, they spend a lot of time on this. I mean, over, I think, 30 pages, 37 pages. And then they get into clearly established law. They basically say it's clearly established. You can't do these things, right? Let me show you an example. So district court held it was clearly established an officer cannot shoot an unarmed man who does not pose any actual threat, right? And then they cite all these cases. And then, so the officers, what they do? They said, hey, well, the district court said they were unpublished or the officer said they cited all these unpublished decisions, so you can't consider them. And this is crazy. The court actually said, yeah, we're not going to consider them. But they still were able to find a Supreme Court case and other cases to basically say the case gets to go forward. So in the end, in the end, they basically say that a reasonable jury could find that Pitts shot Thomas when he moved towards the bedroom door and made a motion, but that conduct would violate the Fourth Amendment, even though Carr ran towards an officer. So citing that case, shooting him in that case was unconstitutional. And so Carr clearly establishes that an officer may not shoot an unarmed moving suspect. So that is that's kind of some of the interesting cases that's been taking place this week. So are there any other questions before I shut this thing down? Let me go through and look. Let me back up a little bit. Bring this over. Hey, I also appreciate you guys sticking around. I know this stuff's not always as interesting as some of CJ's stories, right? Let me see. You see, I'm just backing up a little bit to go through these things. Yeah, we need to, do you know Texas law professor Dale Carpenter who wrote Flagrant Conduct? No, I do not. Okay, good deal. So I don't see any questions. Again, I appreciate the support. I appreciate you all joining the live, and I appreciate obviously CJ Grisham for coming on and talking about his case and his trial. And I wish him and his client luck and well, not just in the criminal side of this, but also in the civil. And if you have any questions, obviously you can reach out to me on Twitter. I'll put in or X, wherever you call it, my X. I'll put it in the chat, but it's clearly a stab. And then my law firm is grable.law, grable.law. And you can also look me up, Grable PLLC on Facebook. That's the firm Facebook page. If you have any questions, reach out to me, and I'll be glad to. I'm one guy, but I'll be glad to try to see if I can answer it or address it maybe in a video. And appreciate my mod as well for kind of holding the fort down today. And until next time, I'll see you all later. Thank you so much.